Ms. Smith, let me know when you're ready.
Okay. I'm ready.
You are ready. All right, let me check one more thing. Excellent. We got pretrial on as well. Okay, Ms. Rivers, good morning.
Good morning, Judge. I'm ready.
All right, you read my mind. We've got a good flow this morning. We're going to get on the record in Mr. McWell's case. It is, got to get back in there, 25 SC 004-117. Mr. McWell is represented by Mr. Fortis. Both of them are here in court. Ms. Smith is here representing the state. Mr. McWell, Mr. Fortis tells me that you are prepared to enter a plea today. It's an Alford plea. We also call that best interests. So it sounds like there's going to be a disagreement between your version of what happened or nothing happened at all and what the state's going to tell me happened. But you've decided that you want to go forward with your plea. Is that correct?
Yes, sir.
Okay, today, all we're going to do is the legal side of things. Ms. Smith is going to put you under oath, ask you a bunch of questions about your rights and about this case. And then I'll let you know if I accept the plea, then we stop. We're not going to get into, but wait, Judge, let me tell you more about Mr. McWell. That's important information that I will receive from Mr. Fortis. And you'll have an opportunity to say something if you want to, but that'll be sometime after Friday because it looks like Mr. Fortis is it medical records you're trying to get or what is it that is landing on tomorrow?
There was evaluations and things of that nature that we're
Okay,
paying for.
of your client or of people who are complaining witnesses?
My client.
Okay, great. And you have forecast for Ms. Smith generally what it is, or this is going to be news to both of you?
I don't think that we've necessarily talked about it. It's just an evaluation.
Okay.
And things of that I want to bring before the court.
Got it. And what is your confidence level that tomorrow is when you'll get them?
My confidence level per my client, I should be getting them on Friday through the provider.
Okay,
I feel pretty good about that.
Okay.
But I was out of an abundance of caution. That's why I was asking for a Monday or Tuesday, just in case it came in a little bit later or something like that.
got it. Okay,
But we've had meaningful conversations that we both knew it was heading in this direction.
understood. So Mr. McWell, as I said, Ms. Smith's going to put you under oath in just a moment. It's important that during the conversation we have, if at any point you have a question or concern, you let Mr. Fortis know or me know so that one of us can address that. Will you do that?
Yes, sir.
Okay.
Because this is also a first offender request.
Okay. Ms. Smith?
Yes, Judge. Mr. McWell, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Sebastian Raphael McWell.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given this morning?
No, ma'am.
How old are you and how far have you gone in school?
I'm 31 years old and I got a GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
One time.
No.
No.
And are you satisfied with his services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Do.
Also, do you waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
I do.
Mr. McWell, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No, ma'am.
Do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes, ma'am.
Do you also understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence for each charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pled guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
Yes, ma'am.
No.
No, I'm sorry. I'm sorry.
You want to
No.
repeat the question?
Yeah.
Yeah, let's do that question again. Don't just answer yes to everything, because one of them may be, do you want to go to prison for 4 years? And you say, yes, great, I know what we're doing with the
I'm
case.
sorry. I'm sorry.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, ma'am.
Has your lawyer explained what First Offender Act is?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistant, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Can you repeat that, please, one more time?
Real quick.
Okay.
Those are just your trial rights. And so that's what you're giving up in order to enter your, in other words, the right to go to trial, the right to talk to witnesses. So just tell them you understand, you're
Okay.
giving that up.
Okay. Yes, I understand. I understand. Yes.
So you understand those are the rights that you'll be waiving by entering this guilty plea?
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they're waiving by entering this plea?
I am.
Mr. McWell, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, that this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
As to indictment number 25 SC 004117, how do you plead to counts 1 through 3, aggravated assault? Count 4, possession of firearm or knife during the commission of or attempt to commit certain felonies, and counts 5 through 6, criminal trespass.
Guilty, first offender.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction, but if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes, ma'am.
Do you understand that that process has to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes. Yes, ma'am.
Thank you, Mr. McWell. Your Honor, if this case were to proceed to trial, the state would show that on June 28th, 2025, officers of the Atlanta Police Department responded to a shots fired call on 2975 Greenbrier Parkway Southwest, that's in Atlanta, Georgia, and also in Fulton County. When the officers got there, they spoke with the victims, in this case, Asia Watkins and Adriana Watkins, who stated that while exiting the parking lot in their vehicle at 3030 Headland Drive Southwest, that's a Bank of America location, that they were shot at by the defendant in this case, that they previously got into a road rage incident with. When the officer spoke with the victim, they stated that while on the intersection before exiting to go to that Bank of America, the car that they were driving almost got into a wreck with the car that the defendant in this case was in. The person driving that car that the defendant was in, his name is Marquisha Brown. She was the driver, the defendant was the passenger. The victims in this case told the police department that once their cars almost collided, they got into a verbal altercation where they exchanged words with each other. After the victims got off of that exit, that Greenbrier exit, the defendant in this case followed. They then went to the victims. They went to the Bank of America location that I mentioned earlier to withdraw money from the ATM. While at that ATM, the victims told the police officers that the defendant in this case got out of the car, shot at them a couple of times, and then got back in the car and drove off. At this time, nobody was hurt. Nobody was shot from those bullets. However, the officers were able to track down the car that the defendant and that driver was in. Eventually, at the time, the defendant was not on the scene, but the officers did get a chance to speak with the defendant in this case, where prior to and in the police report states that he admitted to shooting the gun. However, like I said earlier, no one was hit by those bullets. Because of that, Your Honor, the defendant was placed under arrest and charged with the offenses we have in front of us. If I didn't say earlier, this also occurred in Fulton County, but those are the facts of the case.
So, couple questions. There are 2 counts of criminal trespass, which are basically damage, I'm assuming, to 2 cars?
Yes.
So, Mr. McWell shot, didn't hit the Watkinses, but I guess hit cars in the parking lot or near the Bank of America?
That's correct. It was 2 cars that was present that the bullets went through their cars.
Okay.
I did speak with the victims that owned those cars, and they would like restitution for the damage that was done. They were providing those receipts, but that criminal trespass charge does come from the bullets that were shot by the defendant going into the cars of the other 2 people.
Okay, and there were 3 Watkinses listed in the indictment: Adriana, Asia, and Amana.
Yes, Amana is the child that was sitting in the back seat.
Okay,
So she's the 3rd person that was being shot at.
got it. And you're saying all 3 of them got out of their car and went either to an ATM or into the bank, but it was while they were effectively pedestrians
Well,
that they got?
I'm sorry.
No, go ahead.
It's my understanding that they pulled up to a drive-up ATM.
Okay.
The driver got out of the car, and that's when the defendant got out to shoot at them.
Okay, and so you think the facts would show one person is out on her feet, the other 2 are still in the car. McWell, not the driver of the other car, a passenger, gets out and fires some shots in their direction.
Yes, Judge.
Okay.
We also have video footage from the beauty supply store that's next to the Bank of America store that shows a car circling around, someone getting out and shooting multiple times.
Okay, that car being Ms. Brown's car.
That's correct.
Okay, thank you so much.
Excuse me. That's Mr. McWell's fault. I'm sorry.
Judge, hold on 1 second, please. What were you gonna
We'll
say?
get there. Good morning, Ms. Hardy.
That's my vehicle. That ain't Miss Brown's vehicle.
That's
Good
okay.
morning, Your Honor.
How are you?
Wonderful.
Wonderful is a great way to be. Do you have any criminal history information on Mr. McWell?
I have 3, I'm showing 3 arrest cycles, but no felony convictions to report at this time.
Thank you.
You're welcome.
All right. Mr. Fortis, I'm happy to hear from you some now. You certainly will have a chance to say more later. It's clear Mr. McWell wanted to say something, and maybe it was his car that Ms. Brown was driving, neither here nor there in my mind. It's all about the gun. But I don't want to preclude you from saying something right now. We're not getting into sentencing right now. I didn't even ask the state its recommendation. I'm just seeing, is there a factual basis? Did Mr. McWell understand the questions, et cetera, such that there are all the legal requirements for a plea that you are making, it sounds like, under Alford and want to be first offender. I'll defer the first offender piece because that's a sentencing piece until we reconvene. But anything you want to add on the procedural front?
I mean, Judge, I'd like to defer because I think it all encompasses into the sentencing. The only thing that I would say that was left out, that I think that the court should consider for the purposes of why we're here today is 2 things or 3 things. Number one, Mr. McWell's story would be a little bit different in that while there was an argument going back and forth, Mr. McWell, they were going in the same direction. And while they were going into the same direction, the alleged victims in this case continued to follow their car, yelling at them. And actually, when they all got out of the car, the alleged victims in this case picked up a brick, threw the brick through my client's window of the car window. That brick, from my understanding, was turned over to the police. And I do want the court to know that he was not arrested on the scene. He was actually called, I think, by South Fulton or Union APD, and asked about the event. And he was like, hang on, let me just come on down there. They asked him to come down there, and he voluntarily went down there. And at that particular point in time, while he was giving a statement prior to him being represented, he was arrested. So I think that that's a very important point that needs to be told to the court for consideration. Regarding a little bit more in depth of the factual scenario of what happened, that's generically what happened, but I'd like to defer once we get to the sentencing component. But I do think that the state laid out at least a factual basis for that. So no objection on that part.
All right. Mr. McWell, do you have any questions so far about what we've been discussing?
No, sir.
Okay. Well, I'm going to accept your guilty plea. I find there is a factual basis for your plea. I guess let me suss out a little bit more the Alford part, or maybe we can defer that as well, because I'm accepting the plea. It doesn't sound like your client is denying that he got out of the car and fired the gun. You're providing, I'm going to call it justification. Explanation, we'll figure out what it is. If it was full justification, you ought to go to trial. But there's certainly extenuating circumstances that I ought to understand as I'm thinking about what an appropriate sentence is. But it doesn't sound like it's Alford in the sense of, I wasn't there, I wasn't the one who did the shooting, I didn't have a gun or anything like that. The facts that, other than maybe what car was where, and not talking about the brick, but the facts, to me, the operative facts of getting out of the car, pulling out a gun and firing the gun, it sounds like Mr. McWell is admitting that all those things happened, but context is critical. And you have already begun to put it into more context, and we'll do more of that when we reconvene. So I'm not opposed to Alford, but I need to always understand it. And let's take the criminal trespass. If you fired a gun and the bullets messed up someone's car, that's criminal trespass. I don't know what the Alford part of that is.
Well, as far as the criminal damage part of it, I think the court has a good point. But I think as far as the aggravated assault, was it justification, or was it going to be, us asserting a self-defense argument, and whether it was going to rise to the level legally of a self-defense argument?
Got it.
And I think that after much back and forth, I think that what my client realized is several things. Number one, accepting responsibility, putting this behind him, and moving forward, and not wanting to take, what could be an adverse decision by a jury and that risk.
Right.
So,
jury might not be impressed with you shooting at a car that had a little kid in it.
Exactly.
Okay.
And I think that was the determinative factor. But was there potentially a self-defense argument that could have been made? Sure, but it comes down to the reasonableness standard, and do we get there?
Okay. Then, Mr. McWell, as I said, I find there's a factual basis for your plea. I'll accept it as an Alford plea to counts 1 through 4, and then a guilty plea to counts 5 and 6. That's the criminal trespass, the damaging of the 2 other people's cars. Either you had really bad aim, or you weren't aiming directly at the car you were shooting at because you hit 2 other cars. That doesn't change anything we're going to do. I don't like to willy-nilly hand out Alford if there actually there are facts to support it. We'll defer the discussion about first offender, but I do find that your plea is knowing, meaning you've understood what we were talking about. And when you didn't, you and Mr. Fortas had a huddle, then you answered the question. I also find that your plea is voluntary, meaning no one is forcing you to enter this plea, but you've decided after consulting with your lawyer that you want to go forward with this plea. Do you agree with that as both knowing and voluntary?
Yes, I agree.
Okay. Then that's what we're going to do. Mr. Fortas, can someone in my office sign your name to the indictment indicating the plea in this case?
Yes, Your Honor.
Ms. Smith, can we sign for you?
Yes, Judge.
And Mr. McWell, can we sign for you?
Yes, sir.
All right, we'll do that. I think that's all we'll take care of today. Are you still wearing an ankle monitor?
No, sir.
6 months was up, so it came off. Okay. All right. Anything else, Ms. Smith, for now?
Nothing further, thank you.
Do you think you'll have restitution information by next week? It sounds like we're not gonna have trial next week, so it's gonna be easy to find time, consistent with everyone's schedule to get Mr. McWell back
Because
in.
I haven't seen that. I haven't seen any restitution.
Right, well, you'd need to, that's why I'm asking. You can't see it if she doesn't have it.
Right.
Yeah,
I'll push to get it.
okay. I mean, I don't mind deferring it. That's normally how it works. I just was curious if we'd be able to wrap it all up. I'm not gonna delay the sentencing for that. We can always revisit a modification of the sentence if Ms. Smith gets paperwork, you look at it and say, this is legit. Look, there's a picture, a bullet went through the door, it cost $400 to fix the door. That's restitution. That need not prevent us from getting to the more essential part, which is what's going to be the sentence for Mr. McWell. So I think we're at a close for today. I will have Ms. Nelson work with the two of you, Ms. Smith and Mr. Fortis, about scheduling part 2 of this next week. Let Mr. Fortis know your work schedule, because I think I can be pretty flexible.
I'm flexible too. I work for Amazon Flex, so.
Okay, great. Then it'll really be where you have to be and when throughout next week, and we'll find a time.
Next week, the minute I get it, I'll get in touch with Ms. Nelson. I'll copy the DA and then we'll set it down for next week and conclude the matter.
Okay, sounds good. Thank you, everyone.
Thank you, Judge. It's good to see you.